This video is called Equity Stripping 2.0, How the Wealthy Become Poor on Paper Legally. And in the next 60 seconds, I'm going to show you the exact financial test lawsuit attorneys use to decide whether you're worth suing or whether they quietly move on to an easier target. Here's the problem. If you own real estate in the United States, rental properties, apartment buildings, commercial space, even a paid-off home, you may be far wealthier on paper than you realize. And that paper wealth is visible, public, searchable. From a legal standpoint, that visibility is not a compliment, it's an invitation. The promise in this video is really simple. By the end, you'll understand how sophisticated real estate owners legally restructure their assets so they remain valuable in reality and unattractive on paper, changing the economics of lawsuits before they even begin. And the path is straightforward. I'll explain the lawsuit math most people never learn. I'll walk you through the modern Equity Stripping 2.0 framework step by step. I'll show you a real-world composite case study and then cover the mistakes that quietly destroy otherwise good plans. And if you stay with me for the next few minutes, you'll see why many of the wealthiest investors you know don't look wealthy at all, at least not where it matters. Okay, here's the lawsuit math that most investors never learn. Let's talk about how lawsuits actually start. They don't begin in a courtroom. They begin in a lawyer's office. A potential plaintiff walks in, maybe a tenant, a customer, or someone involved in an accident. Before that attorney agrees to take the case on contingency, what do? They run a simple financial analysis. They ask two questions. What assets does this person own, and how much unprotected equity is available? That's it. If the answer is a lot of visible equity, the case moves forward. If the answer is very little free equity, the economics collapse. So that's why equity, not income, not cash flow, is really the magnet. Now, a $2 million property with $1.5 million of exposed equity looks like a settlement waiting to happen. The same property with properly documented liens looks expensive to attack and hard to monetize. So that's not about hiding assets, that's illegal. This is about understanding incentives. Lawsuits follow return on investment. And once you understand that, everything else in this video will really make sense. Okay, here's what poor on paper actually means. When I say poor on paper, I don't actually mean poor. I mean when somebody reviews your public financial profile, property records, lien records, entity ownership, they don't see a large pool of easily accessible equity. Your properties still produce income, you still control them, your net worth hasn't disappeared, but on paper, the free equity, the part a judgment creditor could realistically reach, has been reduced. So that's the difference between wealth and vulnerability. And if this way of thinking is new to you, consider subscribing. Let's see each other again. This channel is dedicated to explaining how high net worth individuals protect what they've built clearly, legally, and without gimmicks. And if you earn money and you lose it all in a lawsuit, then what's the sense of working so hard to earn it in the first place? So go ahead and subscribe so we can explain more advanced strategies like this one in future videos. Okay, Equity Stripping 2.0, not a trick, a system. So let's define Equity Stripping 2.0 clearly. Traditional equity stripping, what we might call version 1.0, happens naturally. You buy a property with leverage, the bank holds a mortgage, and over time, values rise, loans get paid down, and equity quietly accumulates again. The Equity Stripping 2.0 is intentional. It is the strategic placement of legitimate, documented, recorded, structured obligations so the equity does not remain exposed by default. So this is not about fake loans. It's not about backdating documents. It's not about owing yourself money. It's about using real creditor positions, real promissory notes, real lien instruments, and real business purposes structured correctly in calm waters. The upgrade in 2.0 is that these creditor positions are designed to be durable under scrutiny and, if necessary, transferable, get this, to third parties, something plaintiffs' attorneys understand very well. So in a moment, I'll show you how this fits in a real world asset protection blueprint. Okay, let's talk about the 5-layer blueprint that we use for real estate. Here's the framework we used most often for U.S. real estate owners. Layer 1, privacy. Each property is typically titled through a land trust. So here's a property, it's titled to a land trust, property, land trust, and so on. So the land trust is your privacy wrapper so that your personal name isn't the first thing discovered. Layer number 2, liability containment. A state-specific LLC here serves as the beneficiary of each land trust, so you have liability protection. So risk is isolated. One property's problem doesn't infect the rest of your life, okay? Layer number 3, equity management. This is where equity stripping 2.0 lives. So here's an LLC here. So we have properly documented liens supported by promissory notes are recorded against the property. The amount, terms, and purpose all make business sense, okay? Now, number 4, jurisdictional strength. Now, this is critical. We do not move U.S. properties offshore, and we do not place U.S. LLCs inside of offshore entities necessarily. Instead, the secured creditor position, the note and lien, is payable to an offshore LLC that sits inside of a Cook Islands trust when planning ahead. So it looks like this. Here's the offshore LLC inside of the offshore asset protection trust. So in layer 5, where we control the timing, in calm waters, the client or you manage the offshore LLC that's inside the trust. Life is normal. If a lawsuit becomes real, our licensed bonded trustee company law firm in the Cook Islands can step in and protect you from U.S. courts placing the decision-making outside U.S. court pressure. So that control shift is not theoretical. It is written into the structure. So if you'd like educational resources on whether this framework fits your situation, you can visit us at assetprotectionplanners.com if you're serious and not just curious. So first check out our free information. There's a lot of free information on the website. Then if you're serious about it, go ahead and reach out on our contact form. So again, we initially take this LLC that's inside your trust and record liens against the properties. If needed, we get a third-party lender to purchase those liens, and we put the proceeds into your offshore asset protection trust so it is secure, protected, and safe from judgment creditors. That way, your equity in your property has been stripped, and the proceeds from that equity has gone into your international trust that's beyond the reach of your local friendly neighborhood attorney. So let me give you a composite case study. 2 investors, similar net worth, similar properties. So investor A owns several apartment buildings with substantial equity and minimal internal structuring. Investor B planned early. Investor B's properties, all the properties here, are held in separate land trusts for privacy of ownership. We make an LLC the beneficiary of each land trust, except for the personal residence. We don't involve an LLC there. So they're protected, privacy wrapped, and then they're subject to documented liens payable to a secured creditor that's inside of an offshore trust structure. So that's your LLC inside of your trust. We record mortgages against those properties payable to your LLC. So a serious incident occurs. Claims are filed. Investor A is immediately attractive. Large equity, a clear path to collection. The lawsuit escalates, drags on, and eventually settles for millions, much of it paid out of his pocket. Investor B's situation looks very different. When attorneys evaluate the case, they see heavily recorded liens, minimal free equity, creditor position senior to any judgment, a structure that would require years of litigation and uncertain recovery. And at this point, we get the third-party lender involved, so it's not payable to your own LLC anymore. But the proceeds, however, from that third-party lender go straight into your offshore trust. The result? The case de-escalates. Insurance handles the bulk of it. The personal balance sheet remains intact. Same facts, different economics. Okay, so what destroys otherwise good plans? I want to be very clear here. Courts do not punish asset protection. They punish bad timing and bad facts. So here are the mistakes that quietly ruin plans. First of all, implementing structures after a claim is known. Sloppy documentation, no accounting or payment history, concentrating everything in one entity, saying the wrong thing under oath. The most damaging sentence you can ever say is, I did this so nobody could collect from me. What you say instead, truthfully, is I manage risk like a business person. I document obligations properly. I followed professional advice. Words matter. Okay, so here's your own calm waters checklist. Do I know how much equity is publicly visible? That's The first thing you ask, are my properties properly isolated? You can write this down. Are any liens legitimate, documented, and defensible? Is control clearly defined before and during the lawsuit? If you can't answer those confidently, you don't have a plan, you have exposure. So I hope this helped and got you thinking enough that you want to take action. I'm Kevin, the business guy with Lawyers Limited and Asset Protection Planners. I've been in asset protection for 35 years, and for about 30 of those, we've been building Cook Islands trust structures that hold up when pressure hits. Equity stripping 2.0 isn't about hiding wealth, it's about changing the economics of attack. And when the profit disappears, so do most lawsuits. So thank you for watching. I hope you got a lot of good out of this one, and we'll see you in the next one.